Hi, everyone. Maybe I don't need to use this mic. Welcome. Thank you all so much for coming to our naturalization assistance training today. It's really great to see you all here. Great to see a few familiar faces in the room. And really, we're grateful that you took the time to participate in today's training. Your time spent here, but also working with clients at our workshops is super valuable and makes a big impact in their lives on the day to day. So, again, we're so grateful. So, thank you for taking the time. My name is Ana Maria Santamaria, and I am with the Pro Bono Clearinghouse at New York Lawyers for the Public Interest. For those of you who may not know us, we're a nonprofit civil rights public interest law firm. We've been around for about 40 years and work to connect nonprofits with pro bono attorneys to expand their capacity and meet their legal needs. For the past 4 years, we've worked to connect Catholic Migration Services, who's leading this training today, with a number of law firms and corporate legal departments, many of whom are represented in the room, including Cleary Gottlieb, Fried Frank, Arnold and Porter, Simpson Thacher, and Goldman Sachs, among others. To date, our partnership has had about 375 volunteer attorneys assist over 700 clients with their naturalization applications and needs. We've also received close to 2,000 calls on our hotline, and many of those callers have been seen at our naturalization workshops. So I think that is proof to the powerful partnership that we have together, and we're super thankful to all of the firms here, and especially to Cleary for hosting the training and for taking a lead on our hotline work. We really couldn't do this work without each of you here. So again, I just want to emphasize the value that you bring to the table. I'd like to give a big thanks to Cleary and a special thank you to Aquila Brown and her colleague Udemy Oviedo for making this happen. And we're also grateful to Catholic Migration Services. We have Chloe Moore, who is the naturalization coordinator, and Jose Leon, who's a supervising attorney at Catholic Migration Services, who will be leading our training today. So without further ado, I'll turn this over to you. Thank you.
All right. Good afternoon. My name is Jose Leon, and this is my colleague Chloe Moore. We're going to be taking a look at the requirements to become a citizen of the United States. We're going to take a look at the application itself and go through it with you. And we're also going to give you an explanation of how we run our workshops. Because this is being recorded, we ask that you wait till the end for any questions, just because we want to maintain the flow of the video. But before we start, does anyone have any questions or anything you'd like to say? All right. All right, so naturalization and citizenship is governed by the federal statute, INA Section 301 to 301 to 336I, which is 8 CFR Sections 301 to 344, 392, and 499. Something else that the officers look at when they're looking at an, at an application is the USCIS Policy Manual, Volume 12. And this tells officers what they should be looking for, how USCIS interprets the law, and any such things that officers should be aware of when they're interviewing someone or looking through a file when they are looking at an applicant. There are also USCIS interpretations and previous administrative appeals. So if someone was denied naturalization and the person appealed, it's somewhat like regular case law in that there are appeals and decisions that come out of the agency, but it's slightly different because It's different from the federal case law, which we sit in the Second Circuit. So anything that is appealed and goes up to the circuit court also governs how we view certain laws here in New York City. And of course, as we all know, anything that comes out of the Supreme Court is binding on everybody in the United States. Something also that we can look at is the M476, which is a guide to naturalization, and it has a very extensive list of things that they look for and just general guidance as to what the applicants can be subject to when they're applying for naturalization. So now I'm going to go through the naturalization requirements. The first basic one is governed by INA Section 334B, and that is that the applicants shall have attained the age of 18 years. So anyone who is not 18 years of age may not apply for naturalization. It doesn't matter how long the person has been a resident of the United States, or even if he or she meets all of the other requirements. If the person is not 18 years old, he or she cannot apply affirmatively for naturalization. The second important requirement is admission as a lawful permanent resident, and that is under Section 101A20 and 318. So the applicant must be a lawful permanent resident and must have attained that status lawfully. Chloe is going to read the examples that I have created just to make this even clearer for everybody.
Okay, example one, Juan, a citizen of Paraguay, entered the U.S. on a tourist visa and overstayed. 5 years after he arrived in the U.S., his best friend, Alyssa, who was born in Miami, Florida, agreed to marry him in order to get him a green card. Although the marriage was not bona fide or real, the scheme was successful and Juan eventually became a lawful permanent resident. Juan, unfortunately, is ineligible to naturalize.
So we hope that when you get the cases that you're going to be working on in a workshop context, that we have caught any red flags in situations like this. Obviously, there's no way to really know unless the person tells you, but there are things that we look for when we're doing intake and reviewing the person's history that might be indicative that the person has in fact committed a marriage fraud in order to get an immigration benefit. And that's why I say that this person is ineligible to naturalize. Of course, if the person doesn't tell us and there are no red flags, even though the person is technically ineligible, we won't know that.
Okay, the second example, Clara, a citizen of Canada, entered the U.S. with her parents through the U.S.-Canada border when she was 2 years old. The family never returned to Canada, and Clara grew up in the U.S. and has 3 children born in the U.S. Today, Clara is 30 years old, but she never secured lawful permanent residence, so she is ineligible to naturalize.
So because she's not a permanent resident, she cannot apply for citizenship. You need to be a permanent resident before you can do that. The next requirement is residence in the US, and that is governed by INA Section 316A. So an applicant must have lived as a lawful permanent resident in the US for at least 5 years prior to applying for naturalization. So if an applicant has 4 years and 9 months of residence here in the United States as a permanent resident, that is the earliest that the person may apply to naturalize, because that's 90 days before the 5-year mark. They're very strict with that. So if you submit the application 91 days before you hit that 5-year mark, it will be denied. Also, applicants must maintain their U.S. residence from the time that they apply until the time they take the oath of naturalization. There are several exceptions. The most notable that we see in this context is if the person is married to a U.S. citizen, the person may apply for naturalization after only 3 years of being a permanent resident. And the 90-day rule also applies in this scenario. So 2 years and 9 months as a permanent resident would meet the residence requirement. For this, you must show that you are in a marital union with that United States citizen and that you live with that United States citizen. So if the couple is still married but doesn't live together, the person doesn't fall under this exception and has to wait 5 years.
Another thing to note about that, the 3-year rule for marriage, is you do not have to have obtained your green card through the marriage to that U.S. citizen. You just have to have been living with them and married to them for those 3 years preceding the time you file.
Yes. So Chloe, without further ado, example 1.
All right, so John, a citizen of Australia who is married to a citizen of New Zealand, became a permanent resident on February 2nd, 2012. If he is eligible on all of their fronts, he may submit a naturalization application no earlier than November 4th, 2016.
And why are those two dates important?
So he became a resident in 2012 for February of 2012. 4 years and 9 months later would be in November of 2016.
What about the second example?
All right, Maria, citizen of Nicaragua, is married to Trent, a U.S. citizen. Maria became a permanent resident through Trent on July 15th, 2010, and removed the conditions on her green card on July 5th, 2012. Maria and Trent are inseparable. In fact, their friends complain that they constantly kiss and hug in public. Granted, there are no other issues and she is eligible on all of their fronts, Maria can submit an application for naturalization as soon as April 16th, 2013. So this one is an example of the 2 years and 9 months that they have been married and living together.
So the first one is a 5-year example, and the second one is a 3-year example. The next requirement is continuous residence, also governed by INA 316B. A permanent resident must reside in the U.S. a minimum of 180 days per year. If there is a stay abroad of more than 180 days, there is a rebuttable presumption that there's been a break in continuous residence. If the stay abroad is of more than 365 days, then continuous residence is broken, and the person may be charged with abandonment of status at a port of entry. So at an airport, at a border crossing, CBP officers, Customs and Border Patrol officers might determine that the person has abandoned residence and will often either ask them to give up their residence, or if the person refuses to do that, will put them in removal proceedings so that they can fight out the case in front of an immigration judge. There are exceptions to that. So if for some reason someone needs to study abroad or just needs to live abroad for work or any other reason, there is a way to petition for permission from the US government in order to live abroad as a permanent resident. But if the person doesn't do that, then there will be some presumption that the person has abandoned residence, and that could be very difficult to overcome.
All right, more examples. Karen, a citizen of Honduras and an LPR, hates the winter and loves the beaches of Roatan, where she spends 178 days per year. Karen spends 187 days every year in New York and keeps an apartment and a bank account open in Brooklyn. Therefore, she has not broken her continuous residence. That's because she hasn't spent more than 180 days out of the country. Oh, okay. Example. Did you want to add anything to that?
No.
Example 2, Leticia, a citizen of Peru and an LPR, went to Lima for a visit because she was homesick. She stayed there with her sister for 9 months, but eventually decided to return to her husband and daughter in Dayton, Ohio. Leticia could have issues at the border, as there is a rebuttable presumption that her continuous residence was broken. Leticia should wait 4 years and a day from the day of returning to the U.S. to apply for naturalization.
So the only thing I want to say here is I use the word must here, but it in fact should be the word should, because if the person shows that there was a particular reason why he or she stayed abroad, then if it's well documented, the person can submit that before without having to wait the 4 years and 1 day. But it's best practice, if there is no particular reason, or even if there is, to wait for 4 years and 1 day from the time of the return of that trip that lasted between 6 months and a year.
And then in all cases, when someone has spent more than a year, you should wait 4 years and 1 day from the return of that trip of a year or more before applying for naturalization, if you decide to do that.
In fact, sometimes it's best to wait just 5 years because the current application doesn't have trips beyond 5 years. So that trip wouldn't come up on the application. But yes, it's best to wait minimum 4 years and 1 day.
All right. Jürgen, a citizen of Austria and an LPR for 26 years, decided to move back to Europe in 2010. In 2016, Jürgen returned to the US with his Austrian passport and his valid green card. At JFK, the CBP officer noticed that Jürgen had been out of the country for 6 years. The officer asked Jürgen if he would like to relinquish his permanent residence, to which Jürgen refused. The officer took Jürgen's green card and told him he would get a notice in the mail from immigration court where he will have to show that he did not abandon his residence. That would be like an NTA, notice to appear.
Notice to appear. And here it's a little bit clearer. There's no particular reason. It was a long time outside of the United States, and it doesn't matter that the green card is still valid because you're still a green card holder unless you relinquish that status or an immigration judge takes that status away. So the person is still a permanent resident and will still be admitted into the United States, but he, in this case, Jürgen, will have to fight that in immigration court to show that he didn't abandon his status. So determining whether a continuous residence was broken, something that judges are looking at, or even officers at the border, what they're looking at is if the applicant terminated his or her employment in the US while abroad. Did the applicant's family remain in the United States, the immediate family, children, spouse? Did the applicant retain full access of his or her home? So did the person sell his or her home? Did the person stop the lease? And very importantly, did the person work abroad? Because if the person is working abroad, there's a weaker case and fewer arguments that in fact you maintain your residence in the United States.
Natalia, a citizen of Belarus and an LPR since 2008, met Antonio, a citizen and resident of Italy, online. She decided to quit her job at ING, sell her condo in Astoria, and move to Italy with Antonio, even though they had never met in person. The first few months in Milan were a fairy tale, and she loved working at the local gelateria. But eventually, the relationship cooled, and Natalia decided to break up with Antonio and move to New York City after 7 months. Natalia broke her continuous residence and now has a rebuttable presumption that she did so.
So here we see a situation where she relinquished her home, she relinquished her job, and she actually worked abroad. The good thing is that it's a period between 6 months and a year as opposed to over a year. So there's only a rebuttable presumption. There's not, I think she can still explain it away, but it would be difficult because of all of her situation. In contrast to that, let's read example number 2.
Linda, a citizen of Nigeria and an LPR for 4 years, wanted to take care of her mother back in Lagos because she was suffering from lung cancer. Linda's husband and son remained in Austin, Texas. Linda took a leave of absence from work and talked to her supervisor about the situation. Linda's mother passed after 11 months of Linda's arrival. After the funeral, Linda returned to Texas. Although there is a rebuttable presumption that Linda broke her continuous residence, the facts show that her intention was always to return to the U.S. and to resume her life here.
So those 2 examples just show the difference in circumstances, and I think Linda, should she ever be questioned, would have very good reasons why she had to stay abroad for longer than she should have. But always best practice for people in that situation is to go to the embassy in their country and let the consulate know that she can't return for whatever reason, and then she wouldn't have that issue.
And I would say that just in our office, we see a lot of people that kind of fall under the second category where they do spend a long time out, for examples like sick family members, and sometimes like they don't have a job or they live with someone else and maybe don't have their name on a lease here in the US. So it's harder for them to prove that to an officer that, if they didn't get that permission beforehand.
All right. So the next requirement is physical presence, and that is Section 316A1 and 319A of the INA. So the applicant must have been physically present in the US for at least half of the 5, or if applying under the 3-year rule, 3 years immediately prior to the application. So for an applicant who is applying to naturalize based on 5 years of residence, the required time to be physically present in the United States is 30 months, which comes out to 912 days. So if you're completing an application and you notice that when you add up the numbers, they are more than 912 days, then that person is actually not eligible to naturalize. Similarly, for someone applying under the 3-year rule, it would be 548 days, which is 18 months, which is exactly half the time that the person has been a permanent resident. So physical presence is often confused with continuous residence, but they're two distinct things. So it's just important to keep that clear, and I think maybe the examples will do that for us.
I apologize in my pronunciation of this name. Ngoc, a citizen of Vietnam and a Vietnam boat person, LPR since 1982, lives in Plattsburgh, New York, close to the border with Canada. Ngoc has never been married and has no children. His older mother and her older mother and two of her 5 siblings live in Montreal, Canada, about 1.5 to 2 hours away. Since her mother became ill, she started working part-time Monday through Wednesday and drives up to Montreal for the rest of the week. When counting the days she's spent in Canada over the last 5 years, she discovered she had been in Montreal a little over 1,000 days in the last 5 years. She did not break her continuous residence, but she is ineligible to naturalize as she has not been present in the U.S. for at least 912 days in the last 5 years.
So here we see a situation where the person has a lot of small trips that don't break her continuous residence, but she doesn't have the physical presence because she wasn't here for the amount of time required under the statute. The next requirement is jurisdictional, and that's under INA 316A and 319A. So the applicant must reside in the state or USCIS district where the application will be filed for 3 months prior to applying for naturalization. So if you live in New York City, you need to have lived in New York City for 3 months. If you live in Atlanta, then you need to have lived in Atlanta for 3 months.
So this example is kind of when it gets confusing, and we do sometimes see this. Joan, a citizen of Jamaica and an LPR since February of 2012, lives in Brooklyn, New York, Monday through Thursday, and stays at her sister's place in Newark, New Jersey, for the rest of the week. From Monday through Thursday, Joan works as a home health aide, and on Fridays and Saturdays, she works cleaning homes in several New Jersey suburbs. Joan receives her mail in Brooklyn and has a New York state license. Joan is therefore considered a resident of New York for naturalization purposes.
So here what we're looking at is the person's home base, and we take that to be the place where the person has an ID or where the person receives most mail. We have seen a few instances where someone has IDs from different states, but I don't think that's necessarily something that should be happening. You should only have an ID from one state. So that's why we always look at that when we're doing our analysis if the person is eligible to naturalize.
Sometimes people will receive benefits in one state, have a license from another state. So that's where it can also get a bit tricky, and you want to verify that with them.
The next requirement is English literacy, and that is under INA 312A1. An applicant must demonstrate understanding of the English language, including ability to read, write, and speak words, ordinary usage in the English language. So just being able to have a conversation. You don't need to have perfect, flawless English. You just need to be able to hold a conversation with an officer or with anyone around you. So the requirement, like I said, is met if the person can read simple sentences and words in English. And usually in the examination, this will be tested in a civics-related sentence. There are certain exceptions to this English language requirement, and that's if the person is unable to comply because of a physical or developmental disability or mental impairment. And there's a special form for that, where we work very closely with a person's doctor, identifying what the developmental disability or physical disability is and why it prevents that person from applying for naturalization. Um, we don't usually send those types of cases to workshops because they require a lot of work, a lot of follow-up, and it's just not the right place for someone applying under this exception. But people that you will see very often are people who fall under other exceptions, and those have to do with time as a permanent resident and age. So there is an exception for people who are over 50 years old and have lived in the US as an LPR, which means lawful permanent resident, for 20 years or more. There's another exception for people over 55 years of age who have been lawful permanent residents for 15 years or more. And then there's a last exception, which is if you are older than 65 and have been a lawful permanent resident for more than 20 years, then the exam is not only simplified in the sense that the person has to study fewer questions. Instead of 100, they study 20, but also there is no language requirement, so the person can take the exam in his or her language. Another important aspect is knowledge of US civics. And these are things that you study usually in high school, if you go to high school in the United States. It's a set of 100 questions that are given to the applicants before the examination, and the officers pick at random 6 of those questions. If the person gets 6 correct, then that portion of the examination is completed and passed. If the person misses 1 question, then the officer will ask 10 questions, of which the person must answer 6 correct. If the person does not get 6 correct, then the person would fail that part of the examination and will have a second opportunity to come to a second interview to take that examination and hopefully pass. So the exception that I was talking about, which we commonly know as the 65-20 rule, is again here under section 312b3. And they just need to study a little bit less because I think we all understand that that as people age, it becomes a little bit more difficult to study material.
I just also want to add that since there are multiple parts of the exam, the civics, the reading, writing, and the speaking, if a person, for example, passes the civics portion where they're able to answer 6 of the questions correctly, but the officer is unable to just have the conversation with them, when they go back for their second interview, they would only be retested on speaking, for example. Or if they don't get the reading or the writing portion, that's what they would be retested on, not the whole thing all over again. So that's good for people who just struggle with one section.
And Chloe and I go to a lot of these interviews, and people get very nervous when they're in a situation where they're being tested and don't feel necessarily comfortable in that language. So we do see a lot of situations, like Chloe said, where they've studied really hard, they pass the civics questions, but unfortunately, when the officer asks random questions or questions from the application, the nerves get the best of them and they're unable to answer them, so they have to come back for a second interview.
Or people who struggle, who maybe are less educated and don't have a good ability to write. Those people are only going to be given, just the same way with the civics questions, they'll only be given certain words that they have to form into a sentence, so they can, practice writing down those words beforehand. I don't know exactly how many words, but close to 50 that they would have to study. Oh, okay. Examples. How do you pronounce this? Shulan, a citizen of China, has been an LPR since 1975. She was born on August 4th, 1948. Shulan has lived in Chinatown since she first arrived. Her husband only speaks Mandarin, and her 3 children, although completely bilingual, speak to her in only Mandarin. All of Shulan's friends speak Mandarin, but she only watches CCTV. Shulan understands some English, but in a very limited capacity. Because Shulan is 69 years old and has been a permanent resident for 43 years, she can take the simplified exam in Mandarin.
An example of a 6520 exception.
Eduardo, a citizen of Ecuador, became an LPR in August 2002 through his U.S. citizen daughter. Eduardo was born on March 3rd, 1952, in a remote mountainous area of the country and only speaks Quechua and basic Spanish. Because Eduardo has been an LPR for 15 years and is 65 years old, he can take the regular civics exam in Quechua.
So this is an example of 5515, but I also wanted to show that it doesn't matter what language it is. If that is your native language and the language that you feel most comfortable in, then you are allowed that opportunity to take that exam in that language.
And at the interview, they'll call a phone interpreter for that. Marie, a citizen of Haiti, has been an LPR since 2009. She was born on May 19th, 1932. Marie only speaks Creole and limited French. Despite her age, Marie must take the English and regular civics exam if she applies for naturalization.
See this a lot when we do intake, and it's very difficult because a lot of clients see their friends who are their age getting the exceptions, but unfortunately, in this case, Marie just doesn't have 15 years of being a permanent resident, so she would either have to study really hard in order to be able to take this examination, which at her age would be very difficult, or she can wait until she has 15 years as a lawful permanent resident, which is a long time for someone at that age.
Or she may have a disability that makes her eligible for the waiver, the disability waiver.
So the disability waiver, which Chloe was just talking about, under INA section 312B1, the requirement shall not apply to any person who is unable because of a physical or developmental disability or mental impairment to comply therewith. That is the exact language. Like I said before, there's a lot of work that we do with doctors in order to get a good N648, which is the form that needs to be filled out by the medical professional. And in theory, USCIS cannot second guess what the doctor says, but in practice, we see that officers are not very forgiving and are very tough on these waivers. So sometimes they're denied, and the difficult thing about that is that you don't know until the day of the interview whether it's going to be approved or not. So if it's not approved, then the officer just starts speaking English to the person, and the person might not speak English at all. So our office always goes to these interviews just because we've done a lot of work on them, and also because we don't want someone to be in that situation where it's very uncomfortable for the person. If USCIS does approve the waiver, then the applicant doesn't have to speak, read, or write, depending on what the doctor has indicated. So for example, if someone had an injury where he or she can't write but can speak English, then the doctor would have said, okay, this person can speak English and can study for the civics examination, but can't write. And so it just depends on what disability we're talking about. And what we're trying to waive. Sometimes it's all three, sometimes it's one, sometimes it's two of them. Another very important requirement is the oath of allegiance, and that is under INA section 337. The most important thing is, because we're a nation of laws, and the supreme law of the land is the Constitution, everybody who becomes a U.S. citizen must support the Constitution of the United States and have at least a basic understanding of what the Constitution says. With that comes renouncing any loyalty or any allegiance to any foreign prince, any foreign country, state, or any king that the person was subject to or a citizen of. Then the person also says that he or she supports and defends the Constitution and the laws of the United States against all enemies, foreign and domestic. There's also some language as to your allegiance to the United States. Um, and then there's another portion that talks about bearing arms on behalf of the United States if the law requires it, or to perform non-combatant service in the armed forces, or to perform work of national importance if it should become important or required by law to do so. So those are the things, the basic requirements of the oath of allegiance that the person takes the day that he or she takes the oath. So there are certain things that are not waivable. For example, supporting the Constitution of the United States. Everyone who naturalizes must support the Constitution. But there are different ways that the person can take the oath depending on restrictions that the person might have. There are situations where someone just doesn't have the mental capacity to understand the oath. And in those situations, you can get a waiver so that another family member can do it for that person. But that must also be quite well documented. And those are cases that you will not see in a workshop context because Chloe and I take care of those in-house. Another exception to that is that you can take the oath in a different site. So if the person just can't move, USCIS is accommodating. There's a lot of legwork that needs to be done for that. But USCIS will go to the person's home, will conduct the interview at the person's home, and if everything is in order, will administer the oath at the person's home or wherever, in a home or wherever the person may be. In regards to the last portion, which is about bearing arms, if because of religious training or belief you can't take that oath, there is a waiver for that. But again, that has to be very well documented that your religion or your beliefs are very strong and that you can't, under your religion or beliefs, take this oath. It's not just being a conscientious objector. It's a little bit more than that. It's a little bit more about your religion and not being able to do that. And there are certain religions that prohibit people from bearing arms. So again, here the affirmation in lieu of the oath. There can be some wordplay, some changes in the wording of the oath if the person just doesn't feel comfortable, if the person doesn't believe in God, for example, can use other words, solemnly affirm, on oath, and doesn't have to say, so help me God, if he or she doesn't believe in God. But generally, like I said before, it's very important to support the Constitution of the United States, and the other things can be worked out depending on the situation of the person. We don't see this very often. I think in the years that we've been doing this, maybe 1 or 2 people have wanted to do this. So it's not that common. Those are the basic requirements and the easy requirements to become a US citizen. But the hardest requirement, and I think the requirement where most people run foul of USCIS, is good moral character. And like many things in the law, this is not very clear, and you have to look at case law and also just interpretations of how USCIS looks at who has and who doesn't have good moral character. And GMC generally is a very complicated and convoluted thing to explain, but we're going to try our best to do that. It falls under INA 316A3, and it just basically says that the person must have good moral character. Now, what does that mean? Difficult to say. So the period that USCIS is looking for good moral character is the 5 years prior to applying for naturalization. That doesn't mean that the government can't take a look outside of that period and look at things that the person did before those 5 years, but for naturalization purposes, they really should be focusing on those 5 years right before the application is made.
I also just want to add in right now, since the whole process of naturalization is taking over a year in most cases, at least in the New York City area, um, good moral character is also required between the time of filing and then that year later when you go to have your interview and do your oath. So um, it would, like in some cases now, it's like 6 years, if you really add the time up. So.
Right, and I think the examples that we have will show exactly what Chloe is saying. But they are looking not only at the 5 years prior to the application being filed, like Chloe said, but also any time that it's pending. So you're not off the hook just because you submitted your application. Um, also, if there's a pattern, if someone, for example, has a pattern of shoplifting, but it's not within the 5 years, USCIS does look at that because they look at all the arrests and all of your history, and they do have access to that. So if they see a pattern, um, even though it might be a little bit older than the 5 years, USCIS can still take that into consideration. So there are certain things that are permanent bars to showing good moral character, and one of those is people who have been convicted of what's called in immigration law an aggravated felony between November 29th, 1990, and when when the GMC law came into effect, which is in 1997. So this is a little bit complicated, and I don't want to get too deep into criminal immigration law. But between the period of 1990 and 1997, there was a form of relief available to people who had committed certain crimes, which are now considered aggravated felonies and make the person ineligible for anything. Um, there was a form of relief before a judge, and the judge could grant that waiver and therefore not take away the person's green card, like it would happen today. So someone who committed the same crime in 1994 and someone who committed the crime in 2004, for immigration purposes, though that matters, right? So the 2004 person, if that offense is considered an aggravated felony, has no real way of staying in the United States and will be removed from the United States. But during the 1990s, there was a way to overcome that. And so we have people who are able to maintain their green cards, but can never become citizens of the United States because they can never show good moral character. Similarly, people who committed the exact same crime in 1984 can naturalize. But here, the example that I created shows someone in the situation where his crimes were in the 1990s.
All right, Jose, a citizen of the Philippines and a permanent resident since 1978, has an extensive criminal history. During the 1980s and early 90s, he accrued three aggravated felonies, but since 1993, his last criminal conviction, Jose changed his life completely. In 2000, ICE caught up with Jose and put him in removal proceedings. Luckily for him, because the aggravated felonies occurred in 85, 88, and 93, the judge could statutorily grant him a form of relief called the 212C waiver, which is no longer available to LPRs who were convicted of aggravated felonies after 1997. Jose wants to naturalize in 2017, but unfortunately he is ineligible and will be ineligible for the rest of his life because he committed an aggravated felony after November 29th, 1990.
So this is an example of someone who is able to maintain his permanent residence, but can never show good moral character and therefore can never naturalize. Another exception that's just not overcomable, if you will, is if you are convicted of murder. You can never become a U.S. citizen because you can never show good moral character. And that is definitely an aggravated felony, I can tell you that much. So the person will probably be removed after he or she completes sentence. There are other statutory bars to good moral character. So being a habitual drunkard is one of them. That we've been able to overcome by showing that the person is fully recovered and is no longer an alcoholic. And also something that we're looking at when we're looking at habitual drunkenness, because the language just isn't clear enough, is did that drunkenness or did that addiction to alcohol result in arrests or things that were important in the person's life? So someone might not have been arrested, and so there's that kind of hazy line as to whether the person is a habitual drunkard or not. Um, but that is definitely something that can be overcome, even though it's a statutory bar. Someone who has come to the United States to engage in prostitution or profited from prostitution or engaged in anything that is considered a commercialized vice. Um, Someone who knowingly encouraged, induced, assisted, abetted, or aided any aliens to enter or try to enter the US unlawfully. That's considered alien smuggling. And we do see this a lot in our practice. Someone who has been convicted of, admitted committing, or admitted the essential elements of a crime involving moral turpitude. Again, I don't want to get too deep into criminal immigration law, but there are certain crimes and convictions that, for immigration purposes, might not seem very severe or very, they just don't seem very like a big deal, but for immigration purposes, they do have significant consequences. One of them is a crime involving moral turpitude. So, for example, anything usually that has to do with stealing, that's usually a crime of moral turpitude. Um, if the person has been convicted, admitted, committing, or admitted the essential elements of a controlled substance violation, and that has to do with drugs, um, and the only exception to that is if the person was convicted of anything related to 30 grams or less of marijuana. Another statutory bar is if the person has been convicted of 2 or more offenses for which the applicant received a total sentence of confinement. So the person was in jail or prison for 5 years or more. Another statutory bar to good moral character is that the person has given USCIS a reason to believe he or she is a drug trafficker. And you see the amount of leeway that USCIS has here to determine, reason to believe by an officer that's huge. Someone, yeah.
Sorry, I also just want to point out that I don't know if we explained this, but the red, I think we have highlighted in red because it's things that we often see at Catholic Migration Services with the people that come in who maybe, deal with the good moral character issues. So.
Right. So I just want to say that even though we're going through all of the requirements, you will not have to do this kind of analysis when you're doing a workshop, because Chloe and I will have already done this, and anything or any cases that present these types of problems have either been told they cannot naturalize, or we're working with them in the office to make sure that they get the right representation, because in a workshop context, we send them out on their own and they take care of their application and the whole process on their own. But some of these cases where there are some good moral character issues, we need to follow up with and really go to the interviews. So someone who has given false testimony for purposes of obtaining or retaining any immigration benefits. So we went over that a little bit before when we looked at the case out of Paraguay where he had married someone for green card. If at any point it's discovered that that was the case, then GMC is out the door. And many other things are out the door, including the green card. The person will definitely be removed from the United States. So any sworn testimony, usually when you go before an officer at USCIS, you swear to tell the truth and you raise your right hand and all of that. So anything that you say to an officer at that interview or at any interview that you've had with the officer is considered to be false testimony if there's any lie in any of those interviews. The oral testimony. What I just want to point out is that it doesn't have to be written. So it's important to take a look at those things. Someone who has spent more than 180 days in jail as a result of one or more convictions. And it doesn't matter when the offenses were committed. We don't see many Nazis anymore, but we do see people from countries that had genocide in the 1990s, for example. So we're looking at, for example, Yugoslavia, any of the ex-Yugoslavia countries, or Rwanda, any of those places where there has been genocide, officers will definitely ask those questions. I think they actually ask them of everybody, but specifically in places where we know that there has been genocide, they will dig really deep into that. There's also a residual clause for good moral character, and that is pretty broad. So the fact that any person is not within any of the foregoing classes that I just went over should not preclude a finding that that for any other reason the person is not of good GMC, good moral character. Conduct of underlying offenses that do not statutorily bar someone from demonstrating GMC are still considered under the residual clause. And the reason that I started out this section saying that it's very difficult to explain what good moral character is that they're the standards of the average citizens of the community in which the applicant resides. So that is what we're really looking at, or what officers are really looking at when they're looking at good moral character. So at one point in New York City, for example, jumping the turnstile was a big deal, and people were getting arrested, and people were getting a criminal record because of jumping the turnstile. That has evolved over the years, and now people usually just get tickets. So in the past, jumping the turnstile was considered a crime involving moral turpitude in New York, whereas now it's just a ticket and it's not a big deal. So things do evolve with GMC, but it is supposed to be what the community standards are. Again, the Constitution does mandate that people anywhere in the United States get the same treatment, what they call a uniform rule of naturalization. So if you're in Texas or if you're in New York, it shouldn't matter when you go to your interview, but that is actually only in practice. If you're in Texas, it's very different than if you're in New York. But luckily for all of our applicants, we are in New York. There are also regulatory bars to good moral character. So like the statutory bar, it's automatic if it's committed within the statutory period. And when I say statutory period, I mean 5 years before the application. So USCIS may find that the applicant lacks good moral character based on conduct that occurred within the statutory period, even if it is not listed in the statute. If the applicant demonstrates extenuating circumstances, USCIS may grant the application. So here in the New York City context, you'll see a lot of people getting arrested for things that initially would be crimes involving moral turpitude, but eventually are just pled down to something more simple, like disorderly conduct. So just yesterday, I was in an interview where the person had such a situation, and the person pled guilty to disorderly conduct as opposed to shoplifting, and the officer still granted the person. The officer can't grant the person naturalization, but allowed the person to move forward in the application process, meaning being able to take the oath of allegiance, because the person was honest and was remorseful. So it's not the end all if there is a little bit in that 5-year period. The officers do have a little bit of say in whether they're gonna grant an application or not, but they are looking at everything. Um, GMC bars continued. So if anyone has practiced or is practicing polygamy, person is just has a GMC bar. Failure to pay child support is something we see a lot in our applicants. Um, but if the failure is due to extenuating circumstances or it's not really your fault, um, then the officers will look at that. We'll see the reasons why the person can't make child support payments. And if the person really is sick or can't work, officers are usually pretty good with allowing that person to move forward. Another way is, as you all know, um, child support is something that you have to, that's a debt for life. So if the person is on a payment plan, and even though the person owes a lot of money, it's still okay as long as the person is on a payment plan. One that I have never seen is extramarital affairs. Frankly, I don't think that's really that important right now for officers. So I've never seen it, but it is there. Unlawful acts under 8 CFR 31610B33. Um, the acts that adversely reflect upon the applicant's moral character are what the officers are looking at, and they could be minor acts. So it's always important to remember that unfortunately, non-citizens are viewed in a different light as citizens. And so things that they get arrested for that citizens also get arrested for may have an impact in their immigration status. So any commission or conviction or imprisonment for an unlawful act is something that puts into question the person's good moral character. So like I was saying, the example from yesterday, the officer did ask this person about every single arrest and what happened in every single arrest and how the person feels about each arrest. So they really are looking at you as a whole, and they're going through your file, your immigration file in detail, trying to find anything that makes you ineligible or can put you in danger.
I'm going to go through these quickly for the sake of time. Elder Harris, a citizen of Canada and LPR since 1980, grew up in the Mormon faith. After immigrating to the U.S., he joined the FLDS in Utah. In 1990, he married his first wife and then married three additional women. He currently lives with all four women. Elder Harris is not eligible to naturalize, and that's because of the polygamy bar. Jean Michael, a citizen of Haiti and LPR since 2000, obtained his green card through his U.S. citizen wife. Together, they had 3 children. In 2009, Jean Michael separated from his wife and moved out of the house. The divorce became final in 2011. Since then, Jean Michael has fallen behind in child support payments because his job in construction has been unstable. He currently owes $25,000 in arrears. Jean Michael wants to naturalize. In order to be successful, he must show why he cannot pay this and a payment plan. If he does this, he may be granted naturalization. That's something that we see often. And with that, we also see people that owe taxes. Same thing, if they're able to show a payment plan and proof that they have been, up to date on those payments, then usually, the officer looks more favorably upon them if they're on a payment plan.
Okay, so other people who are prohibited from naturalizing. So again, anyone who committed an aggravated felony after 1990, we already went over that. But also anyone who's an anarchist, member of the Communist Party or any other totalitarian party, people who advocate for the violent overthrow of the U.S. government, saboteurs, people who write or publish subversive material, deserters from the U.S. Armed Forces, persons who have an order of removal, or persons relieved from military training and service on grounds of alienage. Any of those are people who can't naturalize. Another thing that we see very often in our practice are people who are under or have had probation, parole, or orders of protection. So someone who is on probation, parole, or suspended sentence during all or part of the statutory 5-year period is not automatically barred from applying for naturalization. However, USCIS cannot grant naturalization if the person is still on probation, parole, or suspended sentence. So if within the 5-year period, the person was on parole the first year of the 5-year period, that doesn't mean that the person won't be able to naturalize. But if the person is on parole right now and wants to apply right now, then the person can't do that because USCIS can't grant that. That case is still going, right? You can still mess up and you can still get into trouble. So it's not over until your probation is over. So for orders of protection and probation, usually what I tell the clients is to just wait until that is over and then wait 5 years from that time, because then it really is behind them and the statutory period, allows them to show that they have shown good moral character. Chloe talked about this as well. So not filing income taxes is lack of good moral character. And there are exceptions, and you'll see that a lot when you're filling out applications. So people who don't make enough money to be required to file taxes, that's fine, as long as the person explains that he or she is not required to file taxes. Or for some reason, they just don't file taxes. There has to be something in the person's life that shows that the person just doesn't have to file taxes. Some people have been filing their tax returns incorrectly because there is unfortunately a lot of misinformation for people in the immigrant community when it comes to tax filing. So it's very important that at least within the statutory period, they are able to fix those tax returns and pay any back taxes that they owe because they filed them incorrectly. If the person owes any sort of money to the IRS or to a local government, then, like Chloe said, officers are looking for some sort of payment plan. Just making sure that the person is getting on that. We do have to remember that tax evasion is a crime, and in some instances, it's been said that it's even an aggravated felony. So it's very important that people are doing their taxes correctly and filing those. Selective service only really applies to males between the ages of 18 and 26 who live in the United States. So since 1980, everybody who is in that age range is required to sign up to the selective service. And the only people accepted from that who are males between those ages are people who are here under non-immigrant visas. So for example, a student visa or any sort of visas like that. But even people who are undocumented or who are asylees or refugees are required to sign up to the selective service. There is a waiver available to people who just didn't know or didn't do it, and now it's too late because once you turn 26, then it's over. You can't really go back in time. So usually what we do is we include a waiver saying that the person just didn't know he had to sign up for that, and usually the officers are fine with that. If the person is between the ages of 26 and 31, which is 5 years after turning 26, then the officers might be a little bit more disinclined to grant even with the waiver or not the waiver, with the affidavit requesting that be waived. But after 31, definitely officers understand that it's past the 5-year period and they're okay with saying that you have good moral character even if you didn't sign up.
And people born before 1960.
Yeah, because those people were drafted, not sign up. Okay, so conviction or admission of the following crimes bars the finding good moral character required for citizenship for up to 5 years. So any controlled substance offense, any drugs of any sort, except, like I said before, 30 grams or less of marijuana, a CIMT, unless it's a single CIMT and the offense is not punishable with more than 1 year and does not involve a prison sentence of more than 6 months. So it's getting very deep into crimim, but it is a part of the naturalization analysis. Two or any more offenses of any type where the aggregate prison sentence was 5 years. Two gambling offenses and confinement to jail for an aggregate period of 180 days. This part is really important for people who you will see at the workshop, and it's answering these questions. The first question that applies is, have you ever committed, assisted in committing, or attempted to commit a crime or offense for which you were not arrested? So here we see it's a very inclusive sort of language. It talks about any offense, but when people hear the first part, they get a little bit scared, right? So an offense is, jaywalking is an offense. But so it's very difficult to find someone who will answer yes to this question, but just because we all commit things for which we were not arrested, like we all jaywalk, we're in New York, right? But if it does have some bearing later on in your case, it could be important. So, for example, the Supreme Court has said that if it's something very minor that has nothing to do with whether the applicant would be granted naturalization, then it shouldn't have an effect. But if it's something bigger that would prevent someone from naturalizing, and you said no to that question, then you can be placed in denaturalization proceedings. The next question is, have you ever been arrested, cited, or detained by any law enforcement officer? So here again, it's very inclusive language. So it doesn't just talk about being arrested, it talks about being cited or being detained. So if you're cited to go to court, then you have to answer yes to that question. It's not, I think people just read arrested and then they kind of block that out. But you have to make sure that you explain that to them, that it could be a citation, it could be something very simple. It doesn't have to be an arrest.
One thing to note there, though, is traffic violations. We see many people who will have, like a speeding ticket or a parking ticket, and, that is a citation, but for purposes of the N400, you're not required to include traffic tickets unless the fine was more than $500, or unless it resulted in an arrest.
Right. Which goes very well with the next question, which is, have you ever been charged with committing, assisting to commit, or sorry. So if you've ever been arrested, you have been charged with a crime, whether that's just disorderly conduct or whatever it may be, you have been charged with something. So usually if a person has a disposition, they have to answer yes because the person has been charged with something. And have you ever been convicted of a crime or offense? So for immigration purposes, convictions are include any pleas that you took. And again, here the language is crime or offense. So we will have done that analysis for you before you have to do these applications. But just because you were charged with an offense, that means you might have gotten arrested, but then the case was dismissed. Then you would answer yes to being charged, but no with being convicted because the case was dismissed, or the person has a dismissal in an ACD form. So we will have done that analysis for you. And then, have you ever been placed in alternative sentencing or rehabilitative program? We don't see that a lot here in New York. It's not common practice, but yes or no. And have you ever received a suspended sentence, been placed on probation, or been paroled? Have you ever been in jail or prison? And if so, how long were you in jail or prison? Please make sure that you fill out this section, section 29. Officers get very upset when that's not filled out completely. So when you're filling out those applications, if you do get someone with an arrest, which would be, I think the only thing that you guys would ever see is disorderly conduct, which is an NYPL 24020. Just make sure that you write all of that stuff in completely. I'm gonna go over this very quickly, which is the naturalization interview. So like we said before, the officer is looking to make sure that the person speaks, writes, and reads English, that the person has an understanding of civics, and also that the person has an understanding of the application that was submitted. So the officer does go through every single question sometimes. It depends on the officer, I have to say, but they will definitely go through all of the biographical information that you guys will be filling out. Um, they don't necessarily go into every yes or no question, of which there are many on the application, but they do go over a fair amount of them. So it's very important that the applicant understands every question and that you read every question to the applicant. If the applicant doesn't understand something in the question and you yourselves don't know how to answer, there's always someone around from our team who can help you answer those questions. Now we're gonna get into the actual N400 form, and the reason I put this here is because it must be filled out with black ink. We have often seen in workshops that we get an application for review and it was completed in blue ink, and that means that we have to redo it all. So please, 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 please do it in black ink. And also, I know that some people have their own pens, but we distribute pens in the workshop. And the reason we do that is because sometimes the pens that people use are too thick and they're really hard to read. So please just use the ones that we put out there for you. A huge topic of conversation is names on the N400. And you'll see a lot of people from Spanish-speaking countries, and a lot of them don't even know what their actual legal name is, because it'll say something on their passport, it'll say something else on their green card, and I'm just gonna go over this very quickly, but in Spanish-speaking countries, usually you have a name, then you have your paternal last name, and then you have your maternal last name. So you'll have maybe 4 names: first name, middle name, paternal last name, and maternal last name. You should always go by what's on the passport. The only exception to that is if the person married in the United States and changed names in the United States, because only a court of law can change your name. Just because it says something on your green card, that doesn't mean your name changed. So sometimes you'll see people who didn't get married in the United States, but the person filling out their green card application decided to just put the husband's name. So that's not the person's legal name, and that's the reason there are 2 different boxes in the application. One that talks about the person's full legal name, and then there's one that says what's on your green card. That's the reason why they do that. But I'm not going to go over this specific example. I think you guys can look at it later on your own. Another thing that you'll see sometimes from Latin American countries are women who don't change their names but take on their husband's name, and that is usually with a de, which means of, and then the husband's last name. So you might see someone with 4 names, so first name, middle name, paternal last name, maternal last name, de, and then the husband's name. So that's also a possibility. All right, now let's get into the weeds of what you guys will actually be doing when you're filling out these applications. Part 1 talks about why the person is eligible. So here you have 3 different, or 5 really different examples, but you'll only really be working with A and B usually. So the first one is you've been a lawful permanent resident for at least 5 years. So that's very self-explanatory. The second one is you've been a lawful permanent resident for at least 3 years. And in addition,
We might actually
They're a little bit hard to read.
It's hard to read. Offer them.
Yes, yeah, we always have copies of these on the table so you can reference it. And the nice bolded, I guess, little arrow boxes, those are nice just reminders if you have questions about things that come up often.
But yeah, so yes, those will be circulated at the workshops and easy for you to reference. But usually you're working with A and B. Um, C, D, and E you probably won't see in a workshop context, but if you do, let us know. So like I was saying before, you have the person's full legal name. So here you would put the family name. So in the case of a woman who is from Latin America and did not get married in the United States, then you would put here the paternal last name and the maternal last name. Then the given name would be the first name, and then the middle name would be the middle name. That might be different than what's on the green card. So always reference the passport. Then part two are any other names that the person has had. So let's say this woman got married in the United States and did change her name. So then her legal name would be her married name, and then the name on the green card would be that name. But then she has to put her maiden name, which would be all four names, in the section that talks about other names that the person has used. Something very important that sometimes people forget because it's quite annoying, and in a lot of our workshops, not all, but in a lot of our workshops we're working by hand, is to make sure that you write in the A number, which is that 9-digit number on the person's green card. That has to be written at the top of every single page. So if you look here at where it says part 1, you'll see the A number and the space for 9 digits. And then if you look at the second page, you'll see that at the top, there's also a space for the A number. There's a space for that on every single page, so you have to make sure that you write that in. Then there's an option for people to change names. And the reason that this can be done in the citizenship context is because usually people take their oath at a district court, at a federal district court. So that court has the power to change your name. And you can do that. The only thing is that if you do decide to change your name, you have to go to every single agency and let them know that there was a name change, just the same way as when people get married and decide to change their names. They have to go do that as well. Make sure you fill out the social security number, whether the person is male or female, date of birth, the date when the person became a lawful permanent resident. That should be clear on the newer green cards. On some of the older green cards, it's a little bit more complicated. If you have trouble reading that, let us know and we'll that. Then there's country of birth, which usually coincides with country of citizenship or nationality, but not always. Sometimes someone was born in a country that no longer exists. For example, Yugoslavia, Soviet Union, like countries that don't exist anymore, and now they have a different nationality. So maybe they were born in the Soviet Union in Ukraine, in the Ukrainian Soviet Socialist Republic, and now they're a citizen of Kazakhstan. So they could differ, but usually they're the same. Also, if the person has citizenship of another country, you should list all the countries that the person has citizenship of. If you go down, they're asking about the exceptions. So the 55, 15 and the 50, 5520, the 55, 15 and the 5020 exceptions. So that if the person doesn't have to take the examination in English. Then there's also a space here for accommodations. And again, you won't see much of that, but let's say the person is hard of hearing, then you would write that in. This person is hard of hearing, or speak slowly, or enunciate, whatever the person may need, if there needs to be an accommodation. Question 12 is in regards to the N648 that I talked about that you guys won't see. So you don't have to worry about that. Make sure that for part 4 of the contact information that it's accurate. So make sure that the person actually goes through that and make sure that all the numbers are correct. Same goes for the addresses in the last 5 years. Um, in part 5, 1A, that is the person's actual physical address. It's not always the same address as their mailing address. Often it is, but sometimes it's not. So you have to put in the physical address, and then if the mailing address is different, make sure you complete part B. If they are the same, you don't have to complete part B.
One more thing to note on that is it's really important that you ask someone if, especially the people that we work with, like, is this a secure place to receive your mail? Does mail ever get lost? That type of thing. Because since we are doing these workshops as limited representation, they are the only people getting notices on their case. And if they don't receive a notice, they may not, make it to their interview, and then their case would be denied, for example. So it's really important that, like, even the apartment number is put in, and that they do receive their mail there. Otherwise, we'll have no way of knowing if.
Because we're not, and I know that Chloe will go over this maybe today, but also the day of any workshop, is that we're all just doing this in a limited capacity. Our representation is limited to filling out the application, which is why we don't know after they leave with their completed application if they ever become citizens. We don't even know that. Something also very important with physical addresses is that there can't be any gaps in time. So for the last 5 years, you have to make sure that every single month is accounted for. Information about your parents, this is in regards to whether someone derived or acquired citizenship. If neither parent is a citizen, you can leave it blank. Some people choose to fill it out regardless, but you can just leave it blank if neither parent is a citizen. If one or two of the parents are citizens, then USCIS would like to have as much information as possible about the name, date the person became naturalized, and some clients will have that information available, and some may not. Some will tell you approximately at this, this year. So that's what you would write, approximately 1995.
And that goes for many dates in the application. You'll see, people don't exactly remember when they started living in a place or when they started a job. But if you can ask them for an approximate year and month, that's best. If they can't come up with a month, year is fine, but we prefer a month. You can ask them, like, well, what season was it? Was it cold outside? That type of thing, just to kind of spur their memory.
Yeah. The continuing section is a little bit confusing for a lot of people, and I don't really know why they continue to do this. But it asks about your ethnicity, so Hispanic or Latino or not Hispanic or Latino. What they're really asking here is whether you come from a Spanish-speaking country or not. So you can be Nordic-looking, but you were born in Mexico. Then you'd have to write yes to Hispanic there. Then the race is a different question, and this is a question that often people from, for example, Latin America or places where there's a lot of admixture don't feel comfortable answering, or they just don't know. So you can check all of them, or you can check none of them, or you can check whatever the person feels comfortable with. But in our experience, people from Latin America especially are very confused and they just don't know what to put in there. Then eye color and hair color, that's pretty straightforward. Places of employment, like Chloe said before, similar to places that the person has lived, no gaps. And if the person doesn't know the exact dates, then at least approximate months or years. It's only the last 5 years, so it shouldn't be too complicated.
And you start with now and work back. If you don't have enough room, like there's only three, I guess, employer slots there, you can just use addendum to add information going back 5 years.
Same goes for addresses. Some people move every year or several times in a year. I don't know how they do that, but they do. So make sure that all of those are listed.
There's a lot of questions that come up when you're actually sitting down working with someone in terms of employment. Like sometimes people work as maybe like a babysitter a few days a week, or they're self-employed construction, or maybe they weren't working for a certain period of time. If you have questions about that, you can just flag us during the time. But it's it's best to put something, like I said, like self-employed and as the employer, and then maybe like construction down at the occupation or that type of thing. But even if someone was out of work for like a month or 2 months, you'd want to put that as unemployed and take up an entire slot for that because you don't want to have those gaps in the history.
Yeah. All right, so this goes to what we were talking about earlier about continuous residence and physical presence. So sometimes we will have already counted these days for you in our intake, but sometimes not because we just don't have time to do all of it. One thing to note here, and a tip for everybody looking at this is um, I always look through the passport and I make sure that I list all of the US stamps and I list them all because usually the US is pretty good with entry stamps. There are no exit stamps from the US. And some countries, when you're a citizen of that country, don't stamp you on your way in. So sometimes you'll just have that stamp, and that's really not enough information. Um, there are other ways that we can get this information, and luckily it's only for the last 5 years. Um, but the day that the person comes in and the day the person leaves do not count as days outside of the United States. So it's even if you only spent an hour in the United States that day, that's not considered a day outside of the US for this purpose. And that only really is important when you're very close to 912 days, for example. Um, but if you have any questions as to how to fill this out or how to look for these stamps or anything like that, please let us know that day. Because it can get very complicated. Some people have a lot of trips, a lot of trips. The next section is about marital history. Single, married, divorced, widowed, separated, or marriage annulled. When we say separated in this context, we mean a legal separation. So just because I don't live with my spouse, that doesn't mean that you're separated, unless you went to a court and the court has already started that process. A divorce, some courts require that you do a legal separation before you get a divorce. So that's what they're talking about when they select this separated.
And we hardly ever see a legally separated couple. We do see a lot of people that are living separately, but it's really rare that you'll find legal separation.
I think only a couple in the time I've been doing this, and usually not from New York. All right, so similar to the person who's applying and their name, same goes for spouse's name, right? So current legal name, um, any other legal names that the person had before, or any other nicknames, any names, anything like that goes in there. The date of birth of the spouse and the date of marriage with that spouse are also in there. And then the address of that spouse, and it's the physical address that we're talking about here. Then they also ask about the immigration status of that person. So the question is, is your spouse a U.S. citizen, yes or no? If yes, how did that person get it? Was it at birth or was it through naturalization? And then if it was through naturalization, they want to know what date the person got naturalized. If the person is from another country, and does not have status, we just put in foreign national in there. So, same with children. Full names, if they are a permanent resident, then put in their A numbers. Sometimes if they have naturalized, they will have an A number. Just make sure that all of that information is completed correctly. And then we start with the yes or no questions. Some of these questions are a little bit complicated and they have double negatives. So just make sure that that you read every question carefully to the person, and that the person understands everything in there. But they can be a little bit confusing. And if you have any questions the day of when you're